another independent, once bipartisan federal agency created by Congress in 1914. In that law establishing the Federal Trade Commission, and again, like laws governing several other couple dozen other federal agencies, Congress limited the president's power to remove commissioners, saying that they had to be staggered and they should be bipartisan. Today, the court said that violates the Constitution's separation of powers, that these executive agencies now have so much power that the president has to be able to say he's in charge of them, that the buck stops with the president because they're acting on his behalf, unlike when they were created 100 years ago, and that voters have to know who to hold accountable if you don't like what the FTC is doing. So that's that ruling. A win for the president. He can replace these members of these independent executive agencies like the Federal Trade Commission, the National Labor Relations Board, on, but not the Federal Reserve. That is different. The markets have been watching that case very closely. As you know, Tony, the president had threatened to try to fire former chairman Jerome Powell. So this now will keep the Federal Reserve independent and protected as Congress had intended, Tony.
All right, Jen, thank you very much. Let's bring in Jessica Levinson. She's a CBS News legal contributor and Loyola Law School professor. Jessica, thank you very much for being here. Rebecca Slaughter would have seemed, on the face of it, to have a better case here than Lisa Cook because she was fired for the president for no other reason other than the president saying it was inconsistent with his priorities. That's not cause, as it was written in the law. What does this mean for everybody else at all the other federal agencies?
I think this is such an important question because, as Jan said, this is about a president's power. It's not about Rebecca Slaughter and what her case specifically was, or Lisa Cook and the case that she had in saying that the government should not have tried to remove her. I think we have to look at this through the different lens, which is this is all about what does a president, this is not just about President Trump, what does any president have the power to do? And what the court says today is very consistent with what it has been saying for years, which is when it comes to the executive branch, and specifically these independent executive agencies, that the president does get to fire and hire people at will, as Jan said, because somebody needs to be able to be held accountable. The president is elected to be head of the executive branch. And so I think the point today with respect to Slaughter's case is that it doesn't matter if there was any reason, that this should be, in the court's view, up to the president to decide. And then when it comes to Lisa Cook, we're basically bubble wrapping the Fed. We're saying that's different. It doesn't look like the FTC. It doesn't look like the NLRB. It doesn't look like these other alphabet agencies because what they do is different. And so we have, I think, an acknowledgement that not all agencies are the same, at least with respect to this carve out for the Fed, where the court is saying, looks like a bare majority of the court is saying that Lisa Cook needed some process, that she needed some notice and opportunity to be heard before, in fact, the president tried to remove her. And it's important to note that the president didn't challenge the for-cause provision when it came to the Fed. Of course, that was challenged for the FTC.
All right, Jessica, thank you very much. I want to bring in Chief Washington Correspondent Major Garrett. Major, in many ways, the Supreme Court has empowered this president, but in other significant ways restricted this president. And today we have another mixed decision on that front. What do you make of the politics of it?
The Federal Reserve is different. That's what the Supreme Court said. And there has to be a process by which if the president, any president, is going to fire a sitting Fed governor confirmed for that position by the United States Senate, you have to provide that person, under all circumstances, means by which to challenge the reason that that person was fired. Because the Federal Reserve is not only central to the United States economy, not only was it set up differently than these quasi-independent agencies, it is interacting with the entire global economy. Therefore, the perception and the reality that it is free of political pressure from any chief executive has to be protected, not just judicially, but for the betterment of the entire country. The Federal Reserve, the Supreme Court, as I read this, and I believe Jan and Jessica would agree with me on this, is different. A quasi-independent agency isn't. It has connections to the executive branch, and the executive branch can reach in there and do things that, starting in 1935, the court said, no, we're going to give these quasi-independent agencies a little bit of buffering. Gradually, Court judgments since 1935, that buffering has been eroded. This is the final straw that breaks that camel's back of buffering around these quasi-independent agencies. So they're different. They are much more attuned to the whims and the attitudes of the sitting chief executive, but the Federal Reserve is not. And for those who trade and interact with the U.S. economy, they will breathe an enormous sigh of relief. The politics of it are pretty simple. Everyone in America more or less agrees, and did agree until President Trump came along, that the Federal Reserve did have this special status. President Trump tried to change that. The Supreme Court said, not so fast.
Major, thank you very much. So